Going to call our second meeting of the special committee on physician-assisted dying to order. I believe we have a quorum, and welcome back. This afternoon we begin with witnesses from the Department of Justice, and thank you very much on relatively short notice for appearing before us today. We'd like to take about 20 minutes, and I'm going to be a little bit liberal with you because what you're going to do to help us is to lay the groundwork for where we stand, and given the mandate of this committee to advise the minister on the changes in legislation will be required, your advice and wisdom will be extremely helpful. So 20 minutes. So we have a number of new committee members here. So the process will be that we have 20 minutes from the witnesses, and they're able to divide that time up between them, and I hope they introduce themselves so that we have an understanding of who you are and why you're here. And then we'll begin the first, second, and I expect 3 rounds of questioning this afternoon. Okay, thank you.
Thank you very much. Thank you for the opportunity to be here today as the committee begins its study of the very difficult, complex, and profound question of physician-assisted dying. Before I get going, I would just apologize for not having available my opening remarks in both English and French, which I know the committee likes to see. That is on account of the short notice that we had. So my apologies for that. I'm Joanne Kleinberg. I am Senior Counsel with the Criminal Law Policy Section of the Department of Justice. My colleague here today is Jeanette Attell. She is Senior Counsel with the Human Rights Law Section of the Department of Justice. Just by way of background, ever so briefly, both Jeanette and I were part of the litigation team that worked on the Carter case, helping our litigators behind the scenes. So today I will make some brief opening remarks to provide this committee with some background on the criminal law-related aspects of this issue. It may be helpful to begin with a very brief summary of what the court found in Carter. In its ruling, the Supreme Court found that the blanket prohibitions against physician-assisted dying violated the right to life, liberty, and security of the person in a manner that was not in accordance with the principles of fundamental justice, and that the violation could not be justified as a reasonable limit in a free and democratic society. The court concluded at paragraph 105 that while there are risks to be sure, a carefully designed and managed system is capable of adequately addressing them. As a result, and as noted at paragraph 127 of the ruling, the provisions were found to be unconstitutional to the extent that they prevent competent adults from obtaining assistance to die when they clearly consent to the termination of life and have a grievous and irremediable medical condition that causes enduring suffering that is intolerable to the person. As a preliminary matter, there sometimes appears to be some uncertainty, at least among some Canadians, about what physician-assisted dying is and what it is not. Physician-assisted dying is not the act of withdrawing medical treatment that a patient does not want, nor does it refer to a patient's right to refuse treatment or medicine in the first place. In these circumstances, if death does result from the withdrawal or the refusal of the medication, this is not a crime because the cause of death is the underlying medical condition. No mentally competent person can be compelled to receive treatment they do not want, as this would amount to an assault in criminal law and also a civil wrong. So, physician-assisted dying refers to conduct that involves someone, a physician, actively participating in bringing about the death of another person. Before Carter, this kind of conduct in any form was criminally prohibited in a variety of ways. The court considered that only 2 criminal code provisions were at the core of the prohibition against physician-assisted dying. First, Section 14 of the Criminal Code, which states, "No person is entitled to consent to have death inflicted on him, and such consent does not affect the criminal responsibility of any person by whom death may be inflicted on the person by whom consent is given." Section 14 therefore operates in conjunction with the crime of murder, which is in essence the intentional causing of another person's death. Section 14 means that a person's consent to die has no effect on the criminal responsibility of one who caused their death. It has always been murder, even if the victim wanted to die. Second, paragraph 241B of the Criminal Code, which reads, "Everyone who aids or abets a person to commit suicide, whether suicide ensues or not, is guilty of an indictable offense, punishable up to 14 years in prison." These two provisions prevented a person from receiving a physician's help to die in all circumstances. So it is critical to note, like most other criminal provisions, they are of general nature, and they also serve to prevent non-physicians from helping others to die in situations that are totally outside the context of physician-assisted dying. These two provisions were at issue because there are two ways in which a physician can help a person. One is by providing the person with the means to end their own life, such as by providing or prescribing a lethal dose of drugs. The individual who receives the assistance takes the necessary final actions that cause their own death. They are the agent of their own death with someone else's assistance. This is known as physician-assisted suicide. The other way is generally referred to as euthanasia, and it is where the physician directly causes the person's death, typically by injecting a lethal medication. This does meet the definition of murder, which is the most serious offense in Canadian criminal law, and is punishable by a mandatory sentence of life in prison and at least 10 years of parole ineligibility. Murder is considered the most serious offense under Canadian criminal law and in most other countries because one person is actually causing the death of another, rather than just helping that person end their own life. The differences between the two practices, including the different types of risk that each could entail, formed no part of the litigation before the Supreme Court. The court did not differentiate between the practices, but dealt with both under the general term physician-assisted dying or physician-assisted death. Another general note about terminology: it may not surprise the committee to know that there are differing views on which terminology should be used in this particular context. Some stakeholders take the view that expressions physician-assisted suicide and euthanasia are well defined and clear and must be used in order to avoid confusion and misunderstanding that arise from more general terms like physician-assisted dying. Others disagree with the use of terms physician-assisted suicide and euthanasia, believing that they are loaded and stigmatizing terms and that only something more general like physician-assisted dying should be used. This is just one of the many difficult issues that this committee will face. One overarching consideration the committee will encounter very quickly is the divided jurisdictional nature of physician-assisted dying in Canada. Under our Constitution, Parliament has exclusive jurisdiction for the criminal law. The Supreme Court confirmed in Carter, at paragraph 51, that Parliament has the power to make laws that touch on health on grounds of dangerousness or social undesirability. The criminal law is about morality and fundamental values, such as in relation to concerns about the devaluation of human life. It can also be about public health, such as concerns over risk of abuse and about the safety of individuals, and in particular, vulnerable individuals. Parliament's concerns from a criminal law perspective in the context of PAD relate therefore to the minimization of risks and the protection of social values that are considered of fundamental importance in Canadian society. The provinces and territories also have constitutional responsibilities in the context of physician-assisted dying. They are responsible for hospitals, the delivery of health care, the regulation of the medical professions, amongst other things. At the policy level, the constitutional jurisdiction of the provinces and territories in this area relates to how to make physician-assisted dying available as a beneficial health practice. There are aspects of physician-assisted dying regulation that could be seen to fall squarely within Parliament's criminal jurisdiction, such as the essential elements of an exemption to otherwise criminal conduct. There are also elements that could be seen to fall squarely into provincial jurisdiction, such as conscience protections for physicians that seek to balance the competing rights of physicians against those of patients. There are also issues that could potentially be regulated by both levels of government, but again from different perspectives. By Parliament, from the perspective of minimizing risk and protecting public health and morality, and by the provinces and territories from the perspective of making available a beneficial health practice. In this regard, Canada is unique compared to the other jurisdictions that have legislated in relation to physician-assisted dying. In all other places around the world, the same level of government is responsible for both criminal and health laws. So your challenge is especially daunting. In the United States, 4 states have legislated access to physician-assisted dying. In the country of Colombia, the Supreme Court ruled on 2 occasions that terminally ill individuals had the right to a physician's help to die, and in early 2015, the government published a detailed resolution on the practices that should be followed, though technically this resolution does not have the force of law. In Europe, 3 countries have legislated access to physician-assisted dying: Belgium, Netherlands, and Luxembourg, which collectively can sometimes be called the Benelux countries. You may also hear references to Switzerland, where a form of physician-assisted dying is available. Although the practice is not considered criminal, it is also not regulated in any specific way, so there's no law that you can look to that outlines the situation in Switzerland. Finally, there's also the law in Quebec, which came into force recently. These are the only existing models for physician-assisted dying. These laws have many common features that are important from the criminal law point of view. 1, they permit either one or both practices, that is, either physician-assisted suicide or euthanasia or both. 2, they describe the medical and other circumstances that render a person eligible to receive physician-assisted dying. 3, they contain some form of mandatory procedures to be followed in assessing a request for physician-assisted dying. 4, they contain some form of mechanism to review the patient's request to determine whether all of the applicable rules have been complied with. And 5, they also contain some form of mechanism for the collection of data on all individual cases of physician-assisted dying, which data is then analyzed and made public. Sorry, I've just received a note that, and I will confirm that we will be sharing copies of, copies of the report are on their way to the committee, and the report is also now live on the Department of Justice website, I believe. Sorry for that interruption. I thought you would want to know. Okay, so those are the 5 critical elements that you see in all these physician-assisted dying laws. I'll talk more about these elements shortly, as these really reflect the major policy issues for this committee to look at in considering a Canadian physician-assisted dying law, in addition to determining the extent to which these elements should be addressed at the federal level or left for the provinces and territories to regulate. In terms of procedures for assessing requests, compliance review with requests for PAD, and the monitoring of physician-assisted dying, most laws contain relatively consistent features. However, the choices made in these other places in respect of which practices would be permitted and who is eligible are quite different. In terms of whether physician-assisted suicide and or euthanasia are permitted, about half of the laws permit only physician-assisted suicide, and of the other half, some permit only euthanasia and some permit both. In terms of medical eligibility, the laws can be characterized as falling into 2 categories that are quite distinct at the conceptual level, and as a result, in terms of their scope in concrete human terms. The U.S. laws, Quebec, and the Colombian resolution permit physician-assisted dying only for people who are nearing a natural death that otherwise cannot be avoided. Natural in the sense of as a result of an illness. In essence, these laws give people who are dying, who are at the end of life, a choice of how to die. They can die from their underlying condition, or if they would find such a death prolonged, painful, frightening, or otherwise undignified, they can choose a peaceful death with a physician's help. It should be noted that these laws define the end-of-life circumstances somewhat differently. For example, the U.S. states make a person eligible if they are terminally ill and have a prognosis of 6 months or less, with no requirement that they be unbearably suffering. While the Quebec law, on the other hand, contains a more general requirement that the person be at the end of life, without any reference to a particular prognosis, and does include a requirement that they be suffering unbearably, in addition to some other requirements. The Benelux laws are different. While these laws do provide a choice to individuals at the end of life so they can choose how to die, they also provide people who are not dying but instead who are suffering from serious chronic but otherwise not life-threatening conditions with a choice to end their lives if they find continued living intolerable. Conceptually, these laws provide physician-assisted dying as a means of relieving intolerable suffering from one's medical circumstances, because people can experience suffering not only as part of the dying process, but also from living with difficult medical conditions. As a result, the Benelux approach to eligibility includes a wide range of circumstances, such as people suffering on account of mental illnesses, individuals who are tired of life but not necessarily ill, and individuals who fear future pain or suffering. Data from Belgium and the Netherlands seem to indicate that the circumstances for which physician-assisted dying is sought continues to expand, all within the confines of the law. Over the past several years, there have been a number of high-profile and controversial cases in Belgium and the Netherlands which have received international media attention. It is also interesting to note that the differences in scope of eligibility is also reflected in the Belgian law, where, for example, amendments in 2014 made physician-assisted dying available to children of any age, but only within a narrower scope of eligibility than it is available to adults. Specifically, physician-assisted dying is permitted for children only when the child is dying in the short term and is experiencing unbearable physical pain, but not mental, and only where additional safeguards are satisfied. A review of these laws provides a fairly effective roadmap for the policy issues before this committee. In terms of policy issues to consider, from a criminal law point of view, Parliament would be considering an exemption for conduct that is otherwise criminal, namely the crimes of aiding suicide and murder, which correspond to the two different types of physician-assisted dying. An exemption is needed to shield physicians and possibly other medical practitioners, such as pharmacists and nurses, who may provide assistance in physician-assisted dying from criminal liability. So, first, the committee may consider whether an exemption should be created to only one offense or to both. It may also want to consider whether any specific additional limitations should be made from a safety, risk minimization, public health, and morality point of view, such as whether physician-assisted suicide should be required to be supervised by a physician in order to minimize the risk of a person taking the drugs when they are intoxicated or risk of medical complications from taking the drugs alone. Or instead, whether it would be appropriate for the patient to receive the lethal medication to take home for use at a time and place of their choosing. The committee will likely hear a range of different views on which practice or practices to make available and what the relative merits and risks of each are. The second question is eligibility, which could define the circumstances necessary for the exemption to apply. The court clearly limited its ruling to mentally competent adults, but some stakeholders may express the view that physician-assisted dying should also be available to children, where they are capable of discernment. Only two countries, Belgium and the Netherlands, currently provide access to children. In terms of the person's medical situation, the Supreme Court did not highlight any particular medical condition. They defined the scope of the right from a general medical perspective as applying where a person experienced enduring and intolerable suffering as a result of a grievous or irremediable illness. If one looks at the dictionary, one sees that grievous is typically defined as very serious, severe, or grave. Grievous does not appear to be a medical term. It is employed in the criminal code in the phrase grievous bodily harm, which courts have held to mean a harm or injury that is very severe or serious, but not limited to a harm or injury that is permanent or life-threatening. The court also held that irremediable does not require the patient to undertake treatments that are not acceptable to the individual. On their face, these terms could be interpreted as being quite broad or even narrow. The court, at paragraph 127, expressly limited its ruling to the factual circumstances of the case. Gloria Taylor suffered from the terminal disease of ALS and actually died of natural causes while the court case was still proceeding. And Kay Carter was 88 years old and suffered from severe spinal stenosis, which rendered her largely immobilized. Both women were arguably at the end of their lives. The court said that they make no pronouncements on other circumstances in which physician-assisted dying may be sought. Other aspects of the ruling may arguably appear to equate physician-assisted dying with other forms of end-of-life care. Thus, the scope of the constitutional right pronounced by the court is not entirely clear. The court was determining whether the absolute prohibition was consistent with charter rights. The court also made clear that it was Parliament's task to undertake the policy work and to make the difficult policy decisions. The court recognized, paragraphs 97, 98, and 125, that complex regulatory regimes are better created by Parliament than by the courts, that a number of possible solutions may exist, that the issues involve complex issues of social policy and a number of competing social values. Parliament must weigh and balance the perspective of those who might be at risk in a permissive regime against those who might seek a physician's assistance to die. And a complex regulatory regime would be entitled to more deference from the court than the absolute prohibition. In light of the uncertainty surrounding the meaning of the key terms and the constitutional dialogue that is permissible between courts and Parliament, it is open to Parliament to provide greater or narrower scope to the words of the Supreme Court, provided that it respects the constitutional parameters set by the court's judgment and that the evidence presented to and considered by Parliament justifies such legislative measures. The committee will no doubt hear different views from stakeholders on the question of eligibility and which physician-assisted dying practice should be permitted. Those who are more concerned about individual autonomy will favor more choice and more access. Those who are more concerned about risks to the vulnerable and social values, such as public messaging about the quality and value of lives of individuals with disabilities, will likely favor more limits and restrictions. Other policy issues for the committee to consider could include whether to include procedural safeguards that should be applied in assessing requests, whether to include a mechanism for reviewing whether those procedures had been complied with, and whether to include a mechanism for collecting data for the purpose of analysis and publication and in order to detect trends and potential abuse. Those are my hopefully brief opening remarks. And we would be happy to take your questions.
Very good, and very good timing as well. Thank you. Very thorough and helpful to begin our committee. I'm assuming the committee has questions. And Mr. Rusin, would you like to begin?
Having looked at the legislation that has been put in place in other jurisdictions, what do you see as this committee's greatest challenges in trying to create a framework of our own?
In the Canadian context, the jurisdictional difficulties will be a big challenge. In all the other places, it is one level of government that makes all the decisions and really administers the regime. In Canada, because the regulation of the health practice, the health delivery is under provincial and territorial jurisdiction, but the criminal law is under federal jurisdiction. I think a very big challenge will be deciding which are the aspects of a physician-assisted dying regime that are best dealt with at the federal criminal level, and which are the elements that are best dealt with at the provincial level. And I think another major challenge, more from a policy perspective, will be achieving some consensus on the question of what are the conditions under which a person should be eligible to receive physician-assisted dying.
And if I may follow up, do you know of any other jurisdictions that have studied the possibility of such legislation that have a similar constitutional framework as we do here in Canada?
I don't know of any that have a similar constitutional framework. That said, there certainly are many other jurisdictions that have considered legislation in this area, so there are other models you might wish to look at, but none where I'm aware of their constitutional frameworks.
You mentioned that we might want to look at some other models or other studies. Where would you recommend we also look?
The Parliament of the United Kingdom has looked at this issue quite a few times over the last 20 years. They had a parliamentary committee study the issue in the mid-2000s, I believe. They also recently had something akin to a private member's bill that was debated, and it actually was defeated. I believe it was in September of last year. One of the interesting features of that legislation, it would have adopted a model quite close to the US state model, which is physician-assisted suicide only, and only where the person is terminally ill and facing death in the short term. But one of the interesting things about the UK legislation is that they clearly were uncomfortable with the idea. In the US models, the patient receives the prescription, which they then take home. About 1/3 of patients don't ever take it. About 2/3 do, but they're able to take it whenever they feel the need. And I think that the UK Parliament was troubled by the prospect of those drugs being available to the person, perhaps to take at a time when they were not competent. And so they developed a process whereby the medication would only be delivered to the person at the time when they were going to take it. And they would always be in the presence of a medical professional. If they decided not to take it after it had been delivered, then the drugs would be removed by the medical professional. They could always be brought to the patient again on another occasion. So that's an interesting thing to look at if you're interested in this area, because it does provide a model for a supervised physician-assisted suicide regime.
Thank you.
Have another minute if you'd like to continue, or?
Well, sure. Do you know of any other regimes that you have looked at? Are there any other models for supervised physicians?
That's the only one of that sort that I'm aware of. I believe there also have been some bills studied recently by the legislature of Scotland, and probably also in a number of jurisdictions in Australia. Haven't looked at those very closely. There also are always a handful under debate in legislatures in the various US states. So there's quite a number, and if one goes back 10 years or so, one could find quite a number. Of course, in the Parliament of Canada, there have been private members' bills recently. S225 was introduced in the Senate last session, so that's another model you could look at.
All right, thank you.
Okay,
Yeah, good.
thank you. Mr. Cooper.
Thank you, Mr. Chair, and thank you, Ms. Kleinberg. You spoke briefly with respect to the models in the Benelux countries, and I was wondering if you might comment on your thoughts on whether it would be fair to say that the Supreme Court contemplated a legal regime quite distinct from the Benelux countries, and in that context, I would draw your attention to paragraph 111 of the Carter decision, wherein the court said that cases of assistance in dying in Belgium were inapplicable because, quote, they would not fall within the parameters suggested in these reasons, such as euthanasia for minors or persons with psychiatric disorders or minor medical conditions. I was wondering what your thoughts are on that.
All I can really share with the committee is that there are different ways of reading and interpreting the Supreme Court ruling. Some ways focus on the dictionary definition of the key terms, and some ways may focus more on a contextual reading of the case. So looking to, for instance, there's a variety of places in the court's ruling where they talk about physician-assisted dying in a manner where they compare it to other end-of-life decision-making. So that might suggest to some that they were thinking in more of an end-of-life context. There are the words in paragraph 127 where they talk about the ruling being responsive to the facts of the case and not to any other circumstances. So the facts of Kay Carter and Gloria Taylor's medical situations may be of interest to you. I think it's a very good question, one for which I can't really provide a concrete answer, except to say that it's subject to being interpreted in a variety of different ways, and I guess what I would do is I would bring you back to what the court said was really Parliament's task, which is to make the tough policy choices. I think the court understood that it wasn't its role to be legislating on behalf of Canadians. It was deciding a very specific constitutional question that was before it, namely whether the prohibition in an absolute form was constitutional. So it may be just as important for you to consider the full range of information that is before you than to try to really decipher with precision what it was the court was saying.
Okay. Now, I guess if, for example, Parliament decided to adopt, for example, what might be characterized as a permissive legal framework that would include one or more of the groups identified at paragraph 111, whether it be minors or people with minor medical disorders, it would be accurate to say that that type of framework would run the risk of Section 7 challenge.
I think the starting point is just to note the litigation that's already underway in Quebec in the D'Amico and Saba case, where a constitutional challenge has been brought mainly on division of powers grounds, but also on charter grounds, to the legislation that's recently come into force there. And one of the arguments that's been put forward is that the legislation creates insufficient safeguards to protect the vulnerable, and it's been alleged that that is contrary to the Section 7 life, liberty, and security of the person rights and Section 15 equality rights of people who are at risk under what is alleged to be a permissive regime. I don't think there's any easy answer to your question, though, about what we take from the Carter ruling itself, just because of the way in which cases like this are decided. What was before the court was a very specific constitutional question framed in light of the specific applicants and the specific plaintiffs that were before the court. So the court had to decide whether the blanket prohibition was unconstitutional, but then the further constitutional implications of where the lines get drawn, whether Parliament chooses to go narrower or broader than what might appear to be the language in the Carter decision, is going to be a matter for another new piece of litigation, and we can't really know until we have Parliament's objective and the evidence that was before Parliament how that assessment is going to be made out in the end.
Madame Etel, pour la troisième, c'est Monsieur Rankin ou Madame Soucy?
Ms. Etel, we're going to Mr. Rankin, please.
Pose a question to you, Ms. Kleinberg, on that whether it would be legitimate in your reading of the Carter decision that we would address a question that some of us have been asked about, namely whether in remote communities of Canada where physicians may not be available to provide the constitutionally mandated service the court has unanimously said is available, whether nurses under some sort of supervision might be available for that. Number one, do you think that's a legitimate part of our work? And number two, would that be something that would be within federal domain should we choose to do so?
It's a legitimate part of this committee's work in the sense that any medical professional who, actually I'll reverse myself and I'll start with the second part of your question, was that, which I think was about the jurisdiction responsible for that. Right. So which types of facilities may engage in which types of healthcare practices and so on is probably predominantly a provincial and territorial matter. And the regulation of doctors, the regulation of physicians, what they're each able to do. So I know that some provinces have kinds of nurses who are able to do some functions that are otherwise limited to physicians. That's part of provincial and territorial regulation. On the other hand, from a criminal perspective, I would say there's at least two things you have to keep in mind, but surely there are more as well. The first is if you set up a regime that is such that there are requirements in it that will bar access to some people in remote locations, that may weigh in a court's consideration of the constitutionality of those limits. So any arbitrary barriers to access are something that you should consider. But secondarily, if it is appearing as though medical professionals other than physicians must necessarily be involved or will be involved for reasons of access or otherwise, and in this regard, I'm thinking of pharmacists, so who are the types of physicians who are dispensing the drugs, then any one of those medical practitioners who would be involved may need to be captured by an exemption for otherwise criminal conduct. The failure to include them in an exemption may cause them to be less willing than they otherwise would. So there's a real pure criminal law angle, which is ensuring that any exemption does cover all of those who would be involved. There's also a policy question, which relates to the levels of expertise they have and can they undertake the functions. So for instance, assessing an individual's mental competence is a big part of the delivery of physician-assisted dying. Who's able to do that function? And then thirdly is the question of access. The committee will no doubt hear more types of issues that will also bear on that question, but those are at least the three that come to mind right now.
Bon, vous avez bien établi.
You clearly established the issue of our dual jurisdiction in terms of health. Now, on December 22nd, the Quebec Court of Appeal ruled in favor of the Quebec government, and I would like to know what made the Minister of Justice mandate the Attorney General to ensure that the Quebec Superior Court decision was overturned.
Bon, malheureusement,
Unfortunately, I am not able to explain the reasoning of the minister, but what I can tell you is that because of the fact that we're talking about shared jurisdiction here, criminal law is under the exclusive jurisdiction of Parliament, and that is why the constitutionality of the law in Quebec is at stake here. Now, when you read the Quebec law, you can see that anyone who acts under Section 26 of that Act is not criminally liable. So, to that extent, the court might have said, well, listen, this is a matter of criminal law. It is not up to the provinces and territories to establish what the circumstances are in which a criminal act takes place. So there is a constitutional question around this, and I think that's all I can say. Thank you.
Senator Seidman.
Thank you, Chair. Thank you very much. Complicated issue, of course. In reviewing the Quebec Bill 52, an act respecting end-of-life care, have you encountered problems specifically with regard to those jurisdictional issues that you have put forward as huge challenges? Issues or problems that we might keep in mind specifically when making recommendations for federal legislation?
I don't think so, other than to say, as I mentioned in my opening remarks, the criminal jurisdiction is exclusively federal. So, as my colleague mentioned, there is litigation that's currently suspended in relation to Quebec's law. That's still ongoing. It will be revived either at the time of the expiry of the Supreme Court's suspension, which was just extended for 4 months, as this committee may know, or upon the coming into force of new federal legislation. But that litigation raises the question about whether the parts of, or certain parts of Quebec's law conflict with federal criminal law. Of course, we can understand why the litigation is delayed because at present that federal criminal law is not there. But if the federal Parliament were to amend the criminal code in order to do something narrower, for instance, than what is available under Quebec's legislation, then that could give rise to these constitutional questions. We will really only know the answers to those questions once Parliament has completed its job, and if there is subsequent litigation once that litigation has been completed. So in terms of there being jurisdictional difficulties, I'm not certain that's a helpful way for you to proceed. It may be more helpful for the committee really to stay focused on what it thinks the right solutions are for Canada through the lens of the criminal law, and then any inconsistencies will have to be dealt with at that time. I'm afraid that's, I think, the best way I can answer that question.
So there isn't, in your best expert opinion, there aren't particular aspects of assisted dying that Parliament itself at a federal level should address in legislation, and those that must be left to the provinces?
Well, surely any amendment to the criminal code that says these are the conditions under which conduct that otherwise meets the definition of a crime shall be free from criminal liability. That is exclusively the responsibility of Parliament. There are a variety of ways that Parliament can go about that. It can put very little in such an exemption. It could say, for instance, that so long as the conduct is in accordance with a very detailed provincial law, then that will result in an exemption for criminal purposes for the same conduct. Or Parliament could say, for the criminal exemption to apply, we're going to determine to which offences it applies. We're going to determine under what circumstances it applies. So it would really be with respect to the fundamental circumstances in which physician-assisted dying is available that there's a very strong claim that that is Parliament's jurisdiction as a matter of criminal law. The other aspects of Quebec's legislation are really the protective safeguarding measures. They are things like these are the steps that the physicians must take in working with a patient who's made a request. These are the documents that have to be filled out. Once it has been completed, the documents are sent to the Commission for the purpose of a compliance review and data collection and monitoring so that the public can have confidence that physician-assisted dying is being administered in a safe way, is being administered in accordance with the objectives of the legislation. Those are the kinds of elements where it's more challenging to determine which level of government is best placed to do them. Maybe some of those protective features could be done by both levels of government, at which point you want to balance duplication of effort with ensuring that whatever Parliament thinks is necessary from a federal perspective is present. And in that regard, one of the things that I would bring to your attention is in relation to the compliance assessment function, which most physician-assisted dying statutes have, the bodies that to whom would be referred a case where non-compliance has been found could either be the medical colleges responsible for governing the behavior of physicians, or it could be the police or the prosecution service. And you'll see in a variety of statutes that sometimes they say exactly who the reference should be made to where non-compliance has been found. In terms of Canadian jurisdiction, the regulation of physicians is a provincial and territorial responsibility. Policing and prosecutions are also primarily a provincial responsibility, though in the territories they're more of a federal responsibility, so there's an added complication there. So that's something you might want to keep in mind when the committee is considering which level of government is best placed to do certain functions.
Thank you. That's our time. Thank you, Senator Seidman. Senator Cowan.
Just following up really on my colleague's comments about jurisdiction. It seems to me that it's inevitable that the federal parliament will legislate as in its wisdom, and that provincial legislatures may or may not legislate in areas that they think appropriate. There will be some inconsistencies, there will be some gaps. and then there will be kind of a second round where people will get together to try to reconcile those differences. Is that the way you would see the legislative framework and regulatory framework evolving over a period of time? It's unlikely, is it not, that it would all come together exactly the way the puzzle should?
Really, I know that this committee will be hearing from our colleagues at Health Canada in the coming days. Many of these questions might be better put to them because through their federal, provincial, territorial contacts, they will be most closely working with provincial and territorial health ministries. But I can tell you that the provinces and territories are working diligently on this issue. They are all seized of the issue. They all, or the overwhelming majority of them, work together to appoint a panel of independent advisors to make recommendations to them. So they are in discussions with each other. Internally, they are all following up as diligently as they can. And I think there will be a real concerted effort to have everything in place in the appropriate time frames.
Do you see a particular area that we should be particularly conscious of where the federal and provincial jurisdictions rub together? Some are clearly provincial, some are clearly federal, some are in the purview of the regulatory authorities of the professions.
Right.
But there are some areas where it's not so clear. Can you point us in those directions?
I think the areas where there's the most scope for overlap relate to the procedural safeguards. Things like the physician shall assess the patient's mental competency. The physician shall have discussions with the patient on several occasions. The patient shall fill in a form that is signed and dated and witnessed by at least 3 independent witnesses. I think these are measures which Parliament could consider as part of a regulatory regime from the criminal perspective if they felt that those sorts of details were necessary to protect vulnerable individuals. But that said, those are the sorts of medical practices that are not terribly dissimilar from what physicians already do under applicable provincial regulations and laws and medical policies. So the provinces and territories may well also feel like those are matters that they're quite comfortable dealing with. The question of compliance review, again, is one that I've already talked about, where the bodies to whom a referral would be made if a case of non-compliance had been found would largely be provincial bodies. When you get to the question of data collection and monitoring and oversight for public accountability, public confidence, there have been representations made to the various advisory bodies that have been consulting over the last few months, suggesting that the monitoring at a national level would be especially important. Because otherwise you could have 13 different bodies monitoring and it may become especially cumbersome. So I know that there are concerns about differences and concerns that Canadians might find one regime more friendly to them than another. On the other hand, there are existing mechanisms already in place provincially to deal with discipline of physicians, policing and law enforcement, that sort of thing. So I think those, on the safety features, there's some complications, but perhaps monitoring is the one that stands out the most as that would benefit from a national review. On the questions of medical eligibility, again, that is from a purely criminal law perspective. When we would create a defense or an exemption to a crime, Parliament would normally say it's a defense under these circumstances. So through a purely criminal approach, that is something that would be part of criminal law, but there would be scope if the committee wanted to allow provinces and territories to make those decisions to proceed that way as well.
Thank you. Mr. Arsenault. Mr. Arsenault.
J'ai lu.
Thank you. I've seen about 20 different definitions of euthanasia in both English and French dictionaries, and you've talked about different forms of terminology, but what about this pure definition of euthanasia? It doesn't imply that someone asked for help in dying. So just for the purposes of this committee, what I would like to say is that physician-assisted dying, which is contrary to which is the opposite of the definition of euthanasia, always assumes that a person needs to ask, to verbalize this request to die in an informed manner. So you have studied other countries. So what is the kind of context where someone can say that they gave their free and informed consent and asked for aid in dying to put an end to their lives? Sorry. Yeah, I understood everything you said except the question at the end. So according to everything that you've read about other countries and other states, what would be the definition of free and informed consent with all the information to ask to die? Would you mind if I answered in English? Because it is very technical.
That euthanasia, I may have misspoke when I generalized slightly when I indicated that it was a term that's well understood. Well defined. It is well defined, but there are subcategories of euthanasia. So, in the context of the Carter case, the court was only ever speaking of what could be called voluntary euthanasia, which is exactly where the person is competent to make the decision. So they are aware of their circumstances, they have received the necessary medical information, they are capable of understanding the consequences of the different decisions that they might make. And such a person who requests assistance to die, if they received that assistance from a physician, that would be called voluntary euthanasia. It could be involuntary if, for instance, a physician terminated the life of a patient contrary to their wishes. That could be called involuntary euthanasia. There is another subcategory that could be called non-voluntary euthanasia, which would be where the wishes of the patient are unknown. So I thought it might have been best to try to avoid some of these complications, but it turns out it's impossible. In the Benelux countries, they define euthanasia just as the voluntary termination of human life. So in the European countries, you'll see the term euthanasia used in some of the legislation. It means voluntary euthanasia. Pretty much in all the jurisdictions, voluntary physician-assisted dying is really limited to patients who have requested the assistance, who are mentally competent to make that decision, who have been fully informed of all of their medical situation, the options that are available to them. In the Benelux countries, it is possible for an advance directive for assistance in dying to be made, such that the assistance would be provided when the person was unconscious, but the request was made when they were mentally competent and conscious. So the Supreme Court didn't deal with those sorts of circumstances. They really limited themselves to the situation where the person is competent when they make the request, and also competent when the assistance would be provided. But there are a few notable exceptions in the European countries where physician-assisted dying can be provided in a slightly broader set of circumstances, but always where the request was made by a mentally competent person.
Okay. Ça m'amène à une autre sous-question.
That brings me to another question. Now, you talked about the Benelux countries. Now, would it be possible, could someone ask to be put to death when they are very healthy, well before they are even ill? And so could this constitute informed consent? Could this person indicate that should the case arise, they consent to physician-assisted dying? For example, we can check whether we want to donate our organs on the driver's license. So I'm thinking of that kind of thing.
In the Benelux countries, unfortunately, if I'm permitted the time, I could look it up. I have them with me, but I think that there must be a fairly close temporal connection between the advance directive and the wishes being carried out. So it may be up to 5 years. I would have to confirm that for you. But no, I do not recall seeing any situation where it could be made 20 years in advance and be carried out.
Mr. Warwa.
Thank you, Chair. Thank you to the witnesses from the Department of Justice. I'm sure that almost all of us around this table have been discussing this in a number of different formats, including meeting with constituents, and have heard diverse opinions on this issue. I wanted to confirm with you, and I heard you say it, I believe, but I wanted to confirm that under the Carter decision, you do not have to be terminally ill to qualify based on the Carter decision. That it could be an emotional, irremediable, grievous suffering. It does not have to be a terminal illness. Is that correct?
That is what is not entirely clear. Certainly many commentators have said there's nothing in the Supreme Court's decision that says this is limited to people who are terminally ill. On the other hand, there's nothing in the Supreme Court decision that clearly says this is not limited to people who are terminally ill. Both of those expressions would have taken a very small number of words. Neither one of those statements is there. So we cannot say with certainty what the court had in mind.
Thank you. So the mandate of this committee, special committee, is to prepare a report to the government and in making recommendations that this is what should be included in legislation. The government introduces legislation. If they get this in end of February, they have about 3 months to get the bill through all levels of the House committee, in through the Senate, and then royal acclaim to meet that deadline, which is approximately 3 months. No matter what is introduced in the form of legislation, likely will be challenged, but what I think I'm hearing you say is because of it's not being clear, this committee could recommend that we require it be a terminal illness, and it might meet the Carter decision. Is that what you're saying?
Yeah, I think there's maybe 3 things to keep in mind. The first is, as my colleague pointed out, the indeterminacy within the judgment itself. It's subject to competing interpretations, including the statement where they say this is about the facts of this case. So it's hard to know exactly what the court had in mind. But there's 2 other things I think that are relevant in answering your question. The first is that you have to have regard for the type of evidence that was before the court in Carter in relation to the type of question that the court was being asked, which is, can you have a blanket prohibition? That was round 1. Round 2, as you, I think, rightly predict, will be a different question. That's going to be the question of, we don't have a blanket prohibition anymore. What we have is Parliament's best efforts, based on its objectives and the evidence before it, to strike a reasonable balance between the life, liberty, and security of the person rights of people seeking assistance in dying against the objectives in relation to the protection of the vulnerable. And so the kind of evidence that will be before Parliament and that would be before the court in an eventual challenge will be different, because it would be evidence comparing the relative merits and risks of the different regimes, which really wasn't what the court was looking at in Carter. So we can't know now how the court will respond to that particular question. And then the last piece that I think is also important to bear in mind is the notion of the constitutional dialogue between the courts and between the legislative branch that's been recognized by the Supreme Court of Canada in a number of cases, where the best example, if you're interested in some light reading, is what transpired between the Supreme Court decisions in O'Connor and Mills. But basically what you had happen there was the court articulated a very specific regime that was its way of balancing the competing rights that were at issue in that case. And it was in the sexual assault context, and it had to do with the rules around production of third-party therapeutic records that complainants in sexual assault cases might have. So the court created a regime as a matter of common law that was designed to address the constitutional issues that had been raised in that case. Not long after that decision, Parliament came back with a legislated scheme that differed in some significant respects from what the court had come up with. And what the court said is that it could not be presumed just because Parliament's scheme looked different from what the court had envisaged, that it was unconstitutional, because there's this notion of a dialogue between the legislative branch and courts. And although courts are mandated to uphold the Constitution, and although they provide the general parameters within which legislators must act, they don't necessarily have the last word on how you craft a regime that meets those constitutional parameters. So in Mills, the legislative regime was upheld. So the bottom line there is that there is some scope within which to maneuver. Obviously, you have to have, the committee and Parliament will have to have regard to the principles and the broad parameters that the court articulated in Carter, but at the end of the day, whatever regime Parliament comes up with is going to be assessed against what was the objective that Parliament was striving to achieve, and how well does what Parliament came up with as a solution, is it rational and is it proportionate in terms of a means of achieving that objective? So that's as much of an answer as I think I can give. I hope that's helpful.
Thank you. I'm just going to mention to the committee members, I'm being generous with the time as we go through it, mainly because of the high quality of the answers we're getting. just to let you know, if we don't always get high quality answers, I won't be quite so generous, but the answers are really helpful for our committee. So we've been going over the time limit because your answers are laying a very important foundation for our work. So thank you. Are you okay to keep going? Do you need a break? Are we all? We're good. Okay, Senator Nancy Ruth.
Thanks for raising the issue of access to justice and equitable and affordable access. I wanted to ask, are there any real alternatives to relying on existing consent and capacity laws and processes as recommended by the Provincial Territorial Panel in 17, 20, and 24? And if so, what are the alternatives and how would they work? Do you have any specific concerns about these laws and the processes in this context of physician-assisted death? Consent and capacity laws.
I'm not able to share any concerns necessarily with the adequacy of those laws. All I can do for the benefit of this committee is relay that the jurisdictions that have legalized physician-assisted dying have found that it was necessary to have fairly specific procedures tailored to this context in light of the fact that of the seriousness of the decision being undertaken, in light of the fact that in all of those other jurisdictions, it's conduct that would otherwise be criminal. So in some cases, very specific measures, for instance, the requirement that there be a written request that is signed by the patient and witnessed by 2 or 3 independent witnesses is something that could potentially serve as evidence that a physician complied with the law. It might be a more direct and concrete piece of information, documentary information that can give everyone greater confidence that the individual was acting in a voluntary way, that they were not being coerced by family members, and that the time was taken by all the parties to treat this question with the seriousness that it implicates, given the fact that when the procedure is provided, a physician is contributing to causing the death of a person. So unfortunately, I wouldn't really feel comfortable commenting on the adequacy or inadequacy of existing provincial regulations. Would only bring to the committee's attention that it might want to consider whether more is needed in the circumstances of physician-assisted dying.
Okay, I'm going to move now to the issue of who's going to follow up on this. I know some groups in Canada are very keen to set up special panels or a panel of one that will deal with whether this should be justified and allowed. So my question is, what legal processes do we currently have in place to monitor physician-assisted death cases without adding new entities? For example, we have medical examiners and we have coroners in every province. And I do note your comment about let's have a federal monitoring agency, so that I throw that into the mix, as compared to the review committee and other new processes recommended by the provincial territorial panel. Have we got enough with the coroner system?
That's yet another very good question. Unfortunately, I'm not very familiar with provincial and territorial coroners legislation. It's my understanding that unnatural deaths are brought to the attention of coroners, and then an investigation is undertaken. In terms of whether that alone would be a sufficient process to determine whether physician-assisted dying had been provided in a manner that gave Canadians confidence that the person was mentally competent, had been informed of all of their healthcare options, that they were not under coercion or duress, that I'm not in a position to say, unfortunately. I think it's a very good question, though.
This question is a charter question. I spoke with a well-known constitutional lawyer who often appears before the Supreme Court, who is mentally has issues. And she said to me, how dare you design a law that would exclude us who have mental illness? And if you do so, I'm in court. What's your response to that?
That would be me. I think the response it really falls along the lines of what I've said already, is that, and I think as one of the members has already noted, I think it's not, it would not be unreasonable to conclude that whatever Parliament comes up with will be subject to challenge, whether for being too broad or too narrow, and that there will be inevitably an exercise of line drawing that has to take place, and that will be on grounds of age, on grounds of what kinds of illness, whether mental or physical illness, get you in the door. And what I can tell you is that I'm not in a position to tell you what would be the outcome of that litigation right now, because of course it would depend entirely on that sort of equilibrium between the objective and the evidence that was before Parliament in establishing that this was a reasonable way to strike a balance. Absolutely, it's drawing the line to exclude types of illness could be challenged on Section 15 equality grounds. Similarly, it could be challenged on the same way, on the same basis that that the court found the prohibition violated the Charter under Section 7. But what the court would conclude would really depend on what would be in the record to show why the line was drawn in that way.
Okay.
Sorry.
Represent.
I think we have to move on. Did you have one comment you needed to make?
I only wanted to add, if it's at all helpful to the committee, that the Benelux laws, which have the broader scope of eligibility for individuals who are chronically but not terminally ill, there's not one of them that distinguishes between mental illness and other types of illness. So there's no existing law out there that would allow physician-assisted dying for chronic conditions that are not life-threatening but would exclude individuals with mental illness. It's always an individual assessment of the person's mental competence.
Thank you. Senator Cowan.
Thank you, Chair. Back to the point I was pursuing earlier about patchwork of legislation and regulation. Our objective obviously would be to design a system which would be equally applicable and available to all Canadians wherever they live. and access to that is obviously access to any system is difficult in a country as diverse as Canada, with large urban centres and small rural populations. And if you add to that the federal, provincial, perhaps even professional regulatory players in this mix, do you see a legitimate concern there that whatever it is that we decide as a Parliament of Canada will afford unequal access and unequal, therefore unequal availability across the country? And is there anything that we can do to minimize that other than to continue to talk to federal or provincial counterparts, territorial counterparts, and the regulatory agencies? Is that the answer?
Yes, I think that is the answer. It's very much going to be in the details of what are the kinds of communities where only certain types of medical professionals are available. I've been told that there are some communities in the north where no physicians are available, and there are video links for people to be seen by physicians, and where they may be in fact where they may have only access to nurse practitioners. So those, the committee won't really be able to proceed without getting that kind of detailed information. And again, the concern will be to not be placing barriers in the way of individuals having access unless there's a very good reason for that. But I think that dialogue and hearing from provincial and territorial governments, and likely also our colleagues from Health Canada, will be able to give you more detailed information on these sorts of issues.
Great, thank you. This is my first committee, so I'm not entirely sure what to expect for flow of information, but we've just handed out what looks like a very thorough report. Can you just give, does this come from your department, or where's this coming from?
What you have before you now is the report of the Federal External Panel that was created by the last government, by the Ministers of Justice and Health, to consult with Canadians and with experts and with stakeholders, and to provide they were tasked originally with providing legislative options to the government. On account of the federal election, there was insufficient time for them to be able to produce a report like that by their original deadline, which was November 15th. So the current Ministers of Health and Justice extended their deadline to December 15th, and they also modified their mandate by asking them not to report on legislative options, but only to report on the findings of their consultation activities. So the report before you has some preliminary chapters which discuss some of the things we've been talking about today, the division of power situation, the Carter ruling, followed by a number of chapters that recount the consultations and meetings that they had both with experts from the jurisdictions that we've been talking about that have existing physician-assisted dying regimes, as well as some Canadian experts and some stakeholders, some of the parties that were active in the Carter litigation, and others. So they are documenting for Canadians, but this will be especially important for this committee, the things that they heard from all of those stakeholders and experts. And they also posted online a questionnaire for Canadians to answer. So one of the annexes in the back of the report will have a summary of the findings from the online questionnaire that quite a number of Canadians filled out. So this was commissioned by the previous Ministers of Health and Justice, but it's a report by an independent expert panel. The three members of the panel were Dr. Harvey Chochinov, who's a renowned expert in palliative care from Canada, Dr. Catherine Frazee, who is an expert in disability rights issues, and Benoit Pelletier, who is a law professor and an expert actually in division of powers and federal provincial issues.
Okay, thank you. So we have this piece. I'll be taking it with me home to read, as I'm sure everybody will. And I wanted to make sure that we were gathering all of the work that had been done previously, just to build on the work that has happened. Is this the sole piece that came from the work, or is this a companion piece to other things? I just hope that the committee would actually get full resources from on this file.
Right.
And I don't know if this is it or if there's more to come.
In addition to that report, at the same time as this panel was consulting with Canadians and experts on behalf of the federal government, the provinces and territories appointed an advisory group to undertake largely the same activity, but in aid of the provincial and territorial objectives. They produced their final report, I think it was in mid-December. That is available online. We can absolutely provide it to the committee if it's not otherwise available to you. And there have been many other exercises that have been undertaken in Canada across the jurisdictions over the last year. So quite a number of medical colleges within each of the individual provinces have been examining the issue. And a number of them will have reports that are available online that you can look to. As well, just last week I became aware of a report by the University of Toronto Joint Centre for Bioethics. They created a task force to look at this issue, so this also has a lot of interesting information and viewpoints. So if these are not already available to you through your clerks, please let us know and we can ensure these are all publicly available documents.
Yeah. I think it would be helpful to have the committee somehow gather that a bibliography of works and get it to us. Another question I had is simply around the process of drafting legislation, and so what kind of time frame will the Department of Justice require once we get our work into you? What does that timeline look like? Given yeah, if you could just give us a sense of what that process will involve.
Well, I think what will happen after this committee will make its report to the two chambers of Parliament, and then the ministers will consider the report, and in the normal course they would be discussing with their cabinet colleagues what the federal government's policy ought to be, and from that process we would receive instructions to draft legislation. How long that would take really depends on the detailed nature of it and the number and complexity of the issues.
Best case scenario?
All I really feel comfortable saying is that we at the Department of Justice are very well aware of the timelines, as we know the committee is as well.
Thank you. Thank you. On continue avec Monsieur Arsenault.
We're going to continue with Mr. Arsenault, please. I was wondering if you have examples. Perhaps before asking you this question, I'll give you a bit of context. In the Quebec law, that in the case where a person is severely disabled and unable to ask for assistance in dying, that a third party can make that request. I'm not an expert yet in this matter, but I think I saw something similar in Oregon or perhaps in other states. Do you have specific examples in other countries or states where parameters are established so that a physician can take a direction from a third party who is speaking on behalf of a severely disabled person? No, I don't think that exists. The request must always come from the person who is seeking to die. It must come from that person. It cannot come from a third party. The only circumstances would be in the case of an advance directive where a request was made by the person, but before they have become incapacitated mentally. But it can never come from a third party otherwise. The only exception that I might mention is in the Netherlands. There is a certain protocol between physicians and the attorneys general. That's the Groningen Protocol, and it's mentioned in one of the documents prepared by the Library of Parliament, and that deals with the issue of euthanasia of babies who are severely disabled. So in those circumstances, now it's not part of the legislation. Yes, that's right. It's a protocol, but it's not part of the legislation. Is that correct? But it's accepted. It's done. Is that correct? Yes, it's done very seldom, but it is done. And that would come from the parents with the consent of the parents. The objective of my question, in fact, is to make sure that, because what the Carter ruling says is that we can protect the vulnerable people, but under sections 14 and 241, we're talking about grossly disproportionate. So we have to make sure that we're protecting the vulnerable people. But in a case where a third party could ask for assistance in someone else's death, that comes down to not protecting vulnerable people. That was just my objective in asking you that question with regard to the Groningen Protocol. Well, what I can say is that the court knew full well that when there is an absolute rule and then exemptions are created, then that is a context where one exemption can give rise to another exemption and another exemption and so forth. Like my colleague said, there will always be people who will be on one side of that line and others who will be on the other, and those who are excluded, who are exempted, can be asked to be included. So we can't prevent what is going to happen. We can't foresee what's going to happen, but if Parliament speaks clearly about what its objective is and what its reasons are for this objectives and the limits and the reasons for those limits, then at least this will provide context to consider such cases in future. But we certainly can't read the future. So your interpretation of Carter is that there is no way for a severely disabled person who is unable to express him or herself would be able to give their consent through a third party. I'm just thinking of cases where someone can't speak, they can't move, they're very, very severely disabled. Answer: well, if the person cannot speak, but they have another form of communication, well, obviously it is the will of that individual, but if that person has no way of communicating, well, then we don't even know whether that individual is competent or not. So there is nothing in the Supreme Court ruling that says that a third party can take direction from an individual.
Thank you, Mr. Deltel.
Mr. Deltel. Thank you, Mr. Chair. I'd like to welcome you to our parliamentary committee. Now, I was a provincial member of the National Assembly for 7 years, and therefore I am well aware of the Parliamentary Commission on Dying with Dignity, and I was also there to vote on that piece of legislation. In your opening remarks, you mentioned, and rightfully so, that often we're talking about words, we're weighing words here, and when we're talking about physician-assisted dying, whereas in the Quebec law they talk about end-of-life care. Now, we're talking about the same thing, but with entirely different words. But since we are lawmakers, and the Supreme Court wants us to adopt legislation, then we have to admit that words are very important. Now, in Quebec, we're talking about grievous and irremediable suffering that causes problems that cause unbearable suffering. In your opinion, now, the law that we devise, should that include a definition of those words so that people know what we're talking about? Now, if I understood your question, Mr. Deltel, the Parliament can legislate any way it wants, if that is justified. Yes, I know. you know, I don't want to go back to Churchill, but we know that Parliament can do anything. So, in your opinion, to avoid all ambiguity, should the legislation that we craft, should it contain a definition of the words we use? Answer. Any words that need a definition should absolutely be defined. So, in that context, do you think that this applies? Answer. Well, there are many words. So, you need to choose the words that are the most relevant, that are the most meaningful, and that can be interpreted in a number of ways. Either very narrowly, or very broadly. If the legislator has a certain opinion on what sort of variation it wants, well, then it's always better to be clear, yes. Thank you. So, Mr. Chair, we know that we're trying to protect the most vulnerable people in our society.
Et on doit les protéger, et on doit avoir ces gens-là dans notre esprit.
So, we need to protect these people as we craft this legislation looking to the future. In the same context, my question, ladies, is now what the government is going to craft in the way of legislation, what can it do to prevent this law from going astray? I'm doing this to help the government, you know that. Answer. I really don't know how to answer except by bringing up things I've already mentioned, and that is even the Supreme Court noticed that there are many types of risks for the vulnerable members of our society. For example, the risk that someone might choose to ask for physician-assisted dying because someone in their family is urging them to do so, or because that person has no access to other care, or because they were improperly informed about their actual medical condition, or because they may be mentally unfit for some reason or another. There are many, many types of circumstances where the will of an individual who is requesting physician-assisted dying could be challenged. So to avoid going down this slippery slope and to avoid any errors, you, the legislators, have to reflect on what the risks are and try to find the right answers in order to minimize these risks. As a rule, that would be your objective.
Members, and we're really blessed with two very fine public servants today, and they're answering very forthrightly. It isn't really appropriate to ask them what something should be. It's more important to ask, and it's more appropriate to ask them what is, or what has happened, or something like that. So I just want to caution, it's happened a couple of times now that we're putting them in a little bit of a difficult position by asking them what they think they should do. They can answer that somewhere else, but in this committee, they're public servants responsible for making sure that they help us with that. So, and you've been doing a fine job at that. So, thank you. Madame Sans Souci.
Ms. Sans Souci? Okay, I'll try and make sure I don't do that, Mr. Chair, but in December, the provisions of the Quebec law concerning end-of-life care came into force, and if I understood correctly, you said earlier that our decision should take into account the various provincial legislation. But according to your analysis of the Quebec law concerning end-of-life care, and I don't want to know what we should decide, but rather what your analysis has brought up, should the Quebec law serve as an example for other provinces? Because, you know, it took them 6 years to craft this piece of legislation. So according to your studies, Do you believe that it contains what a piece of provincial legislation could contain? Answer. Yes, I think it is a good example to inform the other provinces and territories of what the array of consequences might be and how this piece of legislation will affect people. In addition, there are aspects that are clearly under provincial and territorial jurisdiction in this piece of legislation, and that is the only law in the Canadian context that the other provinces and territories have as an example. So in that context, yes, absolutely. But I would tell everyone that it is also worth looking at all other pieces of legislation that exist on the topic, because there have been very different decisions that have been made. And the reason for that is, or rather, there are different reasons for that. So in order to do your work by taking into consideration everything, you do have to look at all pieces of legislation. Thank you.
I wonder if you could tell us a little bit more about the Supreme Court's the component of the decision which deals with psychiatric or mental health issues. That came up earlier, and I think it's distinct from the Quebec bill. And I wondered if you could give us some guidance as to what they said so we can consider how far we might go in that regard.
I think that the first thing to note is that they that really wasn't, because that wasn't what they were dealing with. We don't really have a clear answer that was part of the ratio of the decision or part of what they had to decide. There are some comments that actually my colleague might have more at the top of mind than I do, from a policy perspective that they made that give us some clues. But again, like many other aspects of the judgment, the clues point in tension with one another in certain circumstances. So I don't think it's entirely clear, and it certainly was not before the court. So I think it's fair to say that it would be open to the committee to consider psychiatric illness in the gamut of medical conditions that it has to consider, whether it makes sense in light of your mandate to come up with some kind of permissive regime. That is a fair issue for the committee to consider sort of de novo in a way as to whether or not that should be included or not. I don't think you have a clear answer there.
I may be able to add just a few more references to certain aspects of the Supreme Court's ruling that you might find interesting on this point. So the paragraph, really the only place in the Supreme Court's judgment where they talk about mental illness is in paragraph 111, where they say, Professor Montero's affidavit reviews a number of recent controversial and high-profile cases of assistance in dying in Belgium, which would not fall within the parameters suggested in these reasons, such as euthanasia for minors or persons with psychiatric disorders or minor medical conditions. So that's really the only place where they talk about it. The other two aspects of the court's ruling that I would just bring to your attention if you find they may be relevant on this point. One is there are a variety of places, mostly in the first half of the judgment, where they talk about Ms. Taylor and people like her and the kinds of conditions they had in mind. So they mention things like individuals with Huntington's disease or ALS, individuals with terminal cancer. These are the kinds of medical conditions they actually talk about. And then the final point that I would just make, which may be relevant, is that a large part of the basis for their ruling that the absolute prohibition was unconstitutional was that they found that competence and vulnerability can be assessed at the individual basis. They said doctors already, when they're treating patients, are individually assessing that patient's mental competence, whether they're being coerced or making decisions that somebody else is pressuring them to make, whether they're thinking clearly. And it was because the court had express confidence that Canadian physicians can assess both mental competence and the vulnerability of a person at the individual level, that they felt that the absolute prohibition was unconstitutional, and you could both provide physician-assisted dying to those who wanted it while protecting the vulnerable.
Thank you. Senator Siegman.
The Supreme Court decision speaks to charter rights, not only of patients, but also of physicians. And patients, therefore, they have the right to access, but physicians have the right to conscientious objection. So I'm wondering if you have any advice to offer us on how to reconcile what are potentially competing charter rights.
Yeah, I think that that's going to be one that's, as my colleague was mentioning, the issues around and the approach that's taken to how and when physicians may object, that's going to be really a part of the provincial territorial response, most likely. So that, to my mind, would be one of sort of the lower order issues that arises for this committee in terms of what the federal response is going to be. But at a very general level, as with other cases where the court has had to deal with the issue of competing rights of different parties, it always comes down at a very general level to a kind of balancing, and whether whatever balance has been struck is reasonable and proportionate in the circumstances. And I would think that overarching would be the decision and the holding in Carter that there has to be access. So that's sort of the baseline, is whatever approach would be taken to give appropriate respect and protection to the freedom of conscience rights of physicians would have to be reasonably balanced by access for the rights holders that were described in Carter.
Okay, so you're suggesting that it's the provinces that would deal with this particular aspect, the competing charter rights.
Yeah, currently the provinces and territories do have legislation and policies in relation to the rights of physicians to refuse to partake in certain types of medical practices. So it is definitely something that the provinces and territories already are responsible for. There's a fairly limited scope of action on this particular issue from the Parliament's criminal law jurisdiction.
Okay. Do I have a minute for another question? Thank you very much. If I might just change the subject to something you mentioned right at the very beginning of your presentation on terminology. And you said that there are differences in terminology used in discussions by different groups, and there are subtleties implied in their usage. So we know that in Quebec, the term medical aid in dying is used. I have heard that palliative care prefers the term physician-hastened death. And we ourselves see in the Carter decision physician-assisted death, physician-assisted dying. We hear euthanasia, suicide. So there are a lot of terms used. My question to you is, from a legal point of view, what is important when we think about the terminology that will be used in the legislation?
Well, from a criminal law point of view, what would be important to be clear on is which are the criminal offenses for which we're going to create an exemption. So there is an offense, it's called aiding suicide. That doesn't necessarily mean that it wouldn't be possible or appropriate to coin a different term for what I'm calling physician-assisted dying today. But the legal elements from a true criminal law perspective should be clear so that physicians and other medical practitioners can know what they're able to do, what they're not able to do. That's what they will want to give them the confidence if they're otherwise willing to provide this service. So the legal clarity from a proper criminal liability point of view is very important. In terms of, at a more sort of social policy level, what do we want to call this practice? That is a very challenging question. I mean, there's even finer distinctions to be made. And so, for instance, I could bring to the committee's attention that some of the stakeholders who spoke to the federal panel, and you will all see this when you peruse the report, they were also drawing a distinction between dying and death. So dying is a process, whereas death is an event. And so some have even made the recommendation that we should never be calling this physician-assisted dying. Many palliative care physicians feel that that is what they already do. They assist patients who are dying by making them as comfortable as possible through the dying process. But there's also a danger with these kinds of terms, and that is that people don't necessarily understand what they mean. So there was some polling that was done at the time when Quebec's legislation was before the National Assembly, when Quebecers were asked what they thought aide médicale à mourir, or physician-assisted dying, meant. And I think something close to 50% said that they thought it referred to withdrawal or refusal of treatment, which has been legal in Canada for 20 years. So if people are mistaking what a general phrase means, that's not going to facilitate discussions between doctors and patients, and it could confuse things. So I fully recognize the difficult nature of choosing the right terminology on this.
Thank you. Merci. On continue avec Senator Cowan.
Let's continue with Senator Cowan.
We'll go to Ms. Shanahan.
Ms. Shanahan. Thank you, Chair. I'm very interested in the criminal code. I've noticed that the Supreme Court talked about two specific sections, 241B and Section 14. But I have also done some reading.
Play one on TV. Donc, juste comme une personne ordinaire, là, de lire les...
So, just as a layperson, I've been reading these sections, and there are other sections, for example, 226 that talk about hastening death, acceleration of death, and there's another section
by sort of influencing a person. I don't know if that means counseling. Does not apply when a person causes the death of a child or sick person by willfully frightening him. This was all a revelation to me. And 231(3), without limiting the generality of subsection 2, murder, that there's like a contract. Murder is planned and deliberate when it's committed pursuant to an arrangement under which money or anything of value passes or intended to pass from one person to another. So where I'm going with this is, are there other clauses that we should be concerned about looking at that could be called into question and in fact challenged in subsequent court challenges?
There's definitely a number of other criminal code provisions that on the peripheries may be implicated. There's another offense for administering a noxious substance. There are offenses in relation to failures in meeting one's duties to protect human life. But I think that the Supreme Court was correct that the core provisions are Section 14 and 241B. I should also add for the committee to note that Section 241A was raised by the plaintiffs in the Carter case as being relevant, but the court found that it was not core to the prohibition. That is a prohibition on counseling someone to commit suicide. So a number of stakeholders may tell you that they're concerned that that offense might inhibit discussions between doctors and patients. I think that we can help the committee if more information is wanted about what these provisions are, but I think that the level of issues before the committee are at a somewhat higher level. And when the Department of Justice does work on legislation, we go through the entirety of the statute to see if there's other sections that may be affected. And oftentimes there are small consequential amendments that just make sure that something said in one section gets tracked to other relevant sections. So I think it's probably of a lesser priority for the committee to be worrying about those, and a higher priority to be thinking about what the conditions should be, and what medical eligibility should look like. And there will always be some little details to work out, but I think those two provisions that the court identified are really the crucial ones. But any other consideration you want to give to other sections will, of course, be welcome.
Okay, very good. And I do have another question, again, on sort of the laws surrounding this area already. So in Quebec, we have the Civil Code, le Code civil, et on a la possibilité de faire un...
And we can also create a mandate in case of inaptitude, incompetence, and so I'd like to how we have more information on how we could reconcile that with the Quebec law. But for our purposes here on this committee, is there going to be another exercise to look at living wills?
What I would answer to that question is there's nothing in the Supreme Court's ruling that addresses, from a constitutional perspective, that Canadians have the right to make an advance directive for medical aid in dying that would be provided to them after they have lost their ability to say it's what they want or don't want. So there's nothing in the Carter ruling that tells Parliament that's something it has to consider. I can say that the National Assembly of Quebec did not take that step in Bill 52. Certainly there are some who might have sought that, and they did have a special piece of analysis done because that raises very different issues. So for instance, the person for whom who had made an advance directive at the time that a family member may, for instance, be bringing it to the physician's attention, that person is no longer able to say whether they want physician-assisted dying or not. They're not able to articulate the nature of their suffering. So the elements that would need to be presently under the law for a person to access it, at the time it would be provided, a person is not able to say whether they're suffering. So it presents unique challenges for physicians, and is kind of an issue that is dealt with separately. So is it something that Parliament might wish to consider and this committee might wish to consider? It may be, but I don't think there's anything in the Carter ruling that instructs Parliament to go there.
Thank you very much. Mr. Cooper.
Thank you, Mr. Chair. Ms. Kleinberg, in your presentation, you identified a number of common features in jurisdictions that have euthanasia or assisted suicide or both. And one of the common features that you cited were oversight or review mechanisms. It's my understanding that when you look at the European examples, as well as in jurisdictions such as Washington State and Oregon, that those review mechanisms occur after the fact when the individual is already dead. I was wondering if you're aware of any jurisdictions that have oversight in the way of judicial authorization or otherwise at the front end as opposed to the back end.
There's only one, and that's the country of Colombia, which I mentioned in my opening remarks. In early 2015, the government promulgated a resolution to guide the practice of physician-assisted dying. And what they foresee in that regulation is that there would be an interdisciplinary committee that would review the patient's requests, and actually not just review the patient's requests, but would almost have carriage of the patient's request and their file through the rest of the process. So the patient would make their request to their physician, and the physician would then notify an interdisciplinary committee that has a lawyer, a physician, and I believe also a mental health expert. and the committee would be sort of part of the hospital administration. And then that committee would take over the patient's case, and they would work with the patient and the patient's family to give them the support that they needed to ensure that palliative care had been offered, and they would accompany the patient basically right through till the end of the process. So that is a sort of independent body, not the physician who would be administering it, that would be ensuring that all of the conditions had been satisfied beforehand.
Now, in terms of the Colombia example, it's my understanding that Colombia has had euthanasia, at least on some level, for the last 16 or 17 years. And it's my further understanding that this framework that has recently been unveiled is a consequence of a Colombian court decision that said that there simply were not enough checks and balances at the front end to protect vulnerable persons. I was wondering if you might be able to elaborate on the history in Colombia.
I will do my best, but before I do, if I may, I have forgot to mention in response to the previous question that the UK Private Members Bill, which I mentioned earlier, had been amended by the UK Parliament when it was being studied by the Parliament as a committee of the whole, and what was added to it was a mechanism that would require the person's request to be approved by the family court before physician-assisted dying could be provided. So this bill, as I mentioned, was defeated, so it's not in law, but there is a model, another model that this committee could look to. So returning to Colombia, we have spotty information. It's a little difficult to get the information, but what seems to have happened is there was a decision of the Constitutional Court, which is the High Court of Colombia, in the 1990s that found that a terminally ill person who was dying in the very short term had the right to have a physician provide them with a lethal injection. So euthanasia is what they had considered. And what seems to have happened is that physicians were unwilling to do that on the basis of the court's ruling alone. So the government never did introduce legislation or decide on what the protocols should be. So in about 20 years later, another individual who wanted to have access and who found that they couldn't find a physician who was willing brought another case before the courts. And the Constitutional Court again said, this is a right, and if the government doesn't put rules in place so that everyone can feel safe carrying on this practice, we will do it for the government. So it was shortly after the second constitutional ruling, which was in 2014, that the government did in fact bring forward the resolution.
Thank you. We have time for a short question from Senator Nancy Ruth.
You used the expression I've forgotten what you used, advanced consent, and sometimes it's known as prior consent, or there are other phrases for it. Is there any difference in law between these?
This is one of those questions where I have to say that that is a matter of provincial territorial law, so I can't claim any expertise. I am sure there are some differences in the modalities, so in the technical details about what must the form look like? Is there a specific form that an advance directive needs to be in? How many years in advance can a person make one? There might be some differences. But on the whole, the idea is the same everywhere, which is that people can state, if something happens to me and I become unable to express my wishes, these are my wishes that I want carried out when I'm no longer able to convey them. So the general principle would be the same everywhere, I would think, but there may be some small differences. I would think this might be something my colleagues from Health Canada would be better able to answer.
And this would simply be in the form of a letter of wishes given to your health power of attorney.
I'm sorry, I really, I wouldn't want to speculate.
Okay, my last question is to create some work for you. Is it possible to have some kind of spreadsheet with this new report from the External Review Committee, from the Provincial Territorial Committee, from other committees that have reported as to what they say on issues like consent or eligibility or so on. I mean, it'd be a huge amount of work.
Work, and I'm sure our analysts will help us with that.
Thank you.
Perfect. Thank you very much. We have a large mandate and a short period of time to get it done, and you responded quickly, and I hope you're not going on holidays anywhere quickly, because I just would like to, on behalf of the committee, both thank you and reserve the right to call you back, because you've laid a foundation for us and have given us both answers and more questions. So thank you very much for your time. I just want to hold the committee for one more minute as our co-president fait quelque chose aussi.
Quick piece of information for all members of the committee. With regard to documents from the Library of Parliament, they have a number of documents, a summary of previous studies on legal framework, plain language summary of the Carter Report, euthanasia and assisted suicide in Canada, law in selected countries, federal health power, and these are available to all members and staff, and they are currently available on the Senate portal as well as on the House of Commons Share Plus system. So those documents are all available to you for immediate access.
Okay, I think that is our day, and thank you to the committee and thank you to the witnesses for fine work today, and we will adjourn until Monday morning at 11. Thank you. A reminder to have your witness list and issue list in by Wednesday at 5.